We will now take up Matthew Schrader on the record now in 2025 TR 1342, State of Kansas versus Matthew Kyle Schrader. Jared Regier for the state. Mr. Schrader, do you appear?
I'm here in pro propria persona, sui juris, appearing specially, not generally, and I reserve all my rights, remedies, and objections.
All right. So I find the defendant does appear personally, and Mr. Regier, his charges and penalties, please.
Your Honor, pursuant to the information filed with the court on June 13th of this year, this is a case that appears to involve two charges. Count 1, failed to register a vehicle and classified non-person misdemeanor. Count 2, no proof of insurance, and Class B non-person misdemeanor.
And you said these were allegedly committed when? Which date, according to the document?
Your Honor, the charging language in counts 1 and 2 appear to allege occurrence dates on May 21st of this year.
And location within Butler County?
That appears accurate, Your Honor.
Okay. All right, Mr. Schrader, can you still hear me okay?
Yes, I can.
The hearing begins with the judge calling the case of State of Kansas vs. Matthew Schrader. Right from the start, Matthew announces that he is representing himself and says he is appearing specially while reserving all of his rights and objections. The judge moves forward without arguing over those statements and begins explaining the charges against him. The atmosphere is calm, but it's already clear that this defendant intends to take an unusual legal approach. Do you think representing yourself in court is a smart strategy, or does it usually make things more difficult?
All right, I'm having some issues here, as you can see. In count 1, failure to register a vehicle is an unclassified misdemeanor. It carries its own special penalties of a fine up to $2,500 and a potential sentence of 30 days up to 6 months, although probation is an option and time to pay is an option. And no proof of insurance is a B misdemeanor. That carries a fine of at least $300 up to $1,000 and a possible jail sentence up to 6 months. Now, you do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. Because there is the potential for 6 months jail, you would most likely be appointed an attorney if you qualify for court appointed and cannot afford to pay on your own. On the issue of attorney, do you intend to hire an attorney, apply for court appointed, or waive your right to attorney and represent yourself, sir?
I will waive my right and present myself.
All right, is anyone making you waive your right to an attorney today by any threats or promises?
No.
Or any other reason?
No.
All right, and you do understand for the record that you do have the right to hire or apply for court appointed if you cannot afford to hire. Do you understand that?
Yes, I'm aware of that.
The judge carefully explains both misdemeanor charges and the possible penalties, including fines and jail time. She also makes sure Matthew understands that he has the right to hire an attorney or request a court-appointed lawyer if he qualifies. Instead of asking for legal help, Matthew confidently waives that right and chooses to represent himself. The judge confirms that his decision is voluntary before allowing the case to move forward. It seems like everything is proceeding smoothly, but that calm won't last for long.
All right, I will have the record reflect then that you are knowingly and voluntarily waiving your right to an attorney. You're also exercising your right to represent yourself. I'll have the record reflect that in the docket notes and the journal entry. Now then, let's go through these charges. Count 1, fail to register a vehicle. How do you wish to plead to that? You can plead guilty, and that admits it, and we would proceed to sentencing. You could plead not guilty, denying the charge, and we would set it for trial at a later date. Or the third choice, no contest, means you don't want to admit these charges, but you don't want to admit them, but you don't want to go to trial either. So you'd be pleading no contest. We'd still find you guilty without trial and proceed to sentencing today. Another might be, it's not a plea, but another option might be diversion. The county attorney would offer you diversion if you qualified. You'd have to go online, as I've said several times today, to others. You'd have to apply and see if you qualify. They'd send you a response within the next couple of weeks in the US mail. If you agreed to the diversion terms, you would sign the contract and send it back. And if you did everything you were agreeing to, they would dismiss the charge or charges against you, charges if they're both diverted. So, but do you want to divert or apply for diversion? I'm not going to say you'd get it. I don't know your history, and that would come into play. But how do you want to proceed on the issue of diversion or plea?
When asked to enter a plea, Matthew doesn't choose guilty, not guilty, or no contest. Instead, he shifts the discussion toward evidence. He explains that he has already subpoenaed records from the sheriff's office and wants a hearing before making any plea. From his perspective, he can't make an informed decision until he has access to the evidence. It's an unexpected move that changes the direction of the hearing almost immediately.
Okay, so before we get to that, on the record, I've recently served a subpoena to the sheriff's office for records relevant to my defense, and the sheriff's office has filed a motion to quash that subpoena. So today, I'm respectfully asking the court to schedule a motions hearing so that we can resolve the sheriff's office's motion to quash, and that I be allowed the opportunity to pursue negotiations.
All right, you have filed a written motion for subpoena of what documents from the Butler County
Subpoena
Sheriff?
duces tecum.
Of what?
There are many items on there, and
So you don't know what you've asked them to bring to court?
yeah, I do. I don't have it in front of me, but it's a lot of the typical things like body cam, dash camera footage.
All right, and they have filed a motion or a response to quash at least part of what you requested.
Yeah.
Right, and Destiny, do you have both his motion and the response on the file there in front of you?
I show the subpoena, Your Honor, and then I show the
Motion.
sheriff's office motion to quash.
Okay, all right, well, we will set those for hearing if necessary, but how do you want to plead on these charges before we get to that?
Well, I feel like it wouldn't be appropriate to plea until I get the evidence and I'm able to be informed enough to make an appropriate plea.
All right, so you're telling me you don't want to plead not guilty today, you don't want to plead anything today, is that what you're saying?
Right.
Well, you understand this is the hearing when that happens. We enter a plea at first appearance. That determines what happens from there. But if you're refusing to enter a plea, and based on what you've told me, I am going to enter a not guilty plea.
The judge asks questions about the subpoena and learns that the sheriff's office has filed a motion to quash part of Matthew's request. Rather than arguing back and forth, the judge decides the issue deserves its own hearing. However, because Matthew refuses to enter a plea at this first appearance, the judge enters a not guilty plea on his behalf so the case can continue. It's an important reminder that courtroom procedure doesn't simply stop because a defendant chooses a different strategy.
On your behalf, and we can set this for motions hearing prior to a trial date. So how much time, sir, do you think this motion hearing is going to last? Well, I don't know how much time to reserve on my docket.
Are you asking me?
I'm asking you, sir.
How much time I need?
No, I mean how much time the whole hearing will you anticipate will be?
20 to 30 minutes.
All right, let's be safe. Mr. Regier, have you seen these documents he's referring to?
I have, Your Honor, and what I would tell the court is it would appear that on or about the same time that the written objection to defendant's subpoena dulcis tecum and motion to quash was filed with the court, an entry of appearance was also filed with the court by Mr. Terrence Hulskamp, the Butler County Counselor.
And Mr. Hulskamp entered on behalf of the sheriff's office, apparently. Did he file the response?
That would appear accurate, Your Honor, based off of the information in this before the state.
All right, so it sounds like he'll be the one that will be responding to that rather than you, perhaps, just to that limited issue, or do you know?
The written response and motion to quash does appear to be filed by Mr. Hulskamp, Your Honor.
Attention now turns to scheduling the motions hearing. The judge asks Matthew how much time he believes will be needed, and he estimates around 20 to 30 minutes. The prosecutor confirms that another attorney representing the sheriff's office will likely handle the subpoena dispute. The discussion remains respectful, showing that even when disagreements exist, the court still focuses on keeping the process organized and fair.
All right, let's set a motion hearing on a Wednesday afternoon. Destiny, what do you have available? Somewhere, I would say maybe an hour at the most. And I know that's a lot on the docket because we have so many other things going on, but
And you do want it on an afternoon, Your Honor?
yes, I think so.
We can put it on with the bench trial dockets and still label it as the motion, and we can block off the rest of that day.
What are you
November.
looking at? I'm sorry, I talked over November what?
Nope, you're okay, Your Honor. November 12th at 1:30.
All right, well, that all sounds good. Okay, I'm ordering defendant to reappear for motion hearing on the bench trial docket, November 12th at 1:30. That will be by Zoom. And I trust counsel for the state will, of course, let all of their attorneys know that need to be here. All right, so that's where we are. And then if we decide we need a trial date, I'll set it at that time, Mr. Schrader. Do you understand that?
Yep, sounds good to me.
All right, if there's nothing further, let's see.
Your
We
Honor,
don't,
there are multiple matters still to address.
The court schedules the motions hearing for November 12th at 1:30 p.m. by Zoom. The judge explains that this hearing will determine whether the subpoena dispute needs to be resolved before any trial date is set. Matthew agrees with the schedule, and for a brief moment it appears the hearing is coming to a routine conclusion. But just as the judge prepares to end the session, the prosecutor raises another issue that changes the conversation once again.
go ahead, please.
Your Honor, given the statements made on the record today, the state is requesting a ruling by the court as to whether or not this motions hearing is being set, requested, and this matter is being set over by the defense.
Speedy trial time does count towards the defense, and he is asking for this motion hearing to be set and that it be done before trial. And because he did not enter a plea today, I had to enter one for him. So I will definitely count the time against the defendant.
Thank you, Your Honor. Secondly, this is a defendant who seemingly appears pursuant to the summons, so it would appear that the issue of booking as required by statute, specifically pursuant to KSA 21-2501 section B, is outstanding. The state does have certain special recommendations concerning bond in this case. While the state is not opposed to the court ordering an unrecognizance bond, given that the defendant has seemingly appeared pursuant to a summons, the state, in light of statements made on the record, is requesting a higher bond in this case, at the very least $3,000.
Anything you want to say about your bond, Mr. Schrader, before I declare it?
I object to that.
The prosecutor asks the judge to rule that the delay caused by the requested motions hearing should count against Matthew for speedy trial purposes. The judge agrees, explaining that because the defense requested additional proceedings and a plea had to be entered on Matthew's behalf, the extra time will be charged to the defense. The prosecutor then requests a $3,000 own recognizance bond, even though Matthew appeared voluntarily. What do you think? Was the prosecutor simply following procedure, or was this request more aggressive than necessary?
Since I appeared here as I was supposed to.
All right. At this time, bond is set. You said how much, Mr. Regier, based on that?
$3,000 OR was the state's recommendation, Your Honor.
I will adopt that recommendation. Mr. Schrader, you are ordered to appear at the time given by the officers for booking and processing. Your bond will be set at a $3,000 OR. That means you don't have to put up any money unless you fail to come to court at a later date. But if you fail to come to court, you may be determined to owe $3,000 to the state of Kansas on your bond. So look for the breakout room that says, it'll come up on your screen, invitation to a breakout room, and you'll go in with deputy in court security 2 and set up a date and time. Now, if you fail to follow that order and show up at the date and the time the officer gives you and post a $3,000 OR bond, then I very well may have to issue warrants for you. But right now, because you did appear when you were told, I'm going to make it OR, meaning you don't have to put the money up front. You understand that or have any questions about that, Mr. Schrader?
I think I understand it.
Very well. Look
But-
for that invitation on the breakout screen. And Destiny, if you'll put
And-
that
and
on there
we-
for
so-
Schrader, for the officer in court security too.
What time? So it's November 12th,
The motions hearing is November 12th at 1:30, correct?
1:30.
All right. So please accept that breakout room, Deputy. Are you available for that?
I am.
All right, thank you. So
Matthew objects, pointing out that he showed up exactly as required and believes a higher bond isn't justified. After considering the arguments, the judge adopts the state's recommendation, but clarifies that it is an own recognizance bond. That means Matthew doesn't have to pay any money up front as long as he follows the court's orders and appears at future hearings. The judge also orders him to complete the booking process and warns that failing to do so could result in a warrant and the full bond amount becoming enforceable. This hearing wasn't about deciding guilt or innocence. Instead, it focused on courtroom procedure, self-representation, evidence requests, and scheduling the next stage of the case. The judge allowed Matthew to represent himself, entered a not guilty plea after he declined to choose one, scheduled a motions hearing over the subpoena dispute, ruled that the delay would count against the defense for speedy trial purposes, and imposed a $3,000 own recognizance bond while allowing Matthew to remain free as long as he complies with court orders. The outcome shows how procedural decisions early in a case can shape everything that follows, even before a single piece of evidence is argued before a jury. What are your thoughts? Did Matthew make the right decision by insisting on reviewing evidence before entering a plea? Or was the judge correct to move the case forward according to standard court procedure? If you enjoyed this courtroom breakdown and want more detailed analyses of real court hearings, be sure to like the video, subscribe to the channel, and share your opinion in the comments. Your perspective could be featured in a future discussion.